Omething is happening in a federal courthouse in Manhattan that nobody is talking about loudly enough. A case that has captured the attention of the entire country, a sitting First Lady of the United States sued by one of the most prominent political journalists in America, has been sitting in front of a federal judge since late February, fully briefed. Both sides have made their arguments. All the motions are on the table. The judge has everything she needs to rule. And yet, silence. Complete, unbroken, dramatic silence. No ruling, no scheduling order, no indication of when a decision is coming. For months. And in that silence, if you know how to read it, there is a story. A significant one. Because in federal litigation, silence is never just silence. It is always something. And today, we are going to talk about what that something might be. What it means for Wolff, what it means for Melania, and why the moment that silence breaks, everything in this case changes instantly. Welcome back. Today we are doing something a little different. We are not chasing a new headline or a breaking development. We are doing something more important. We are looking at the thing that is not happening, the ruling that has not come, the decision that Wolff said weeks ago should arrive any day now, and has not. Because in law, what does not happen is often as significant as what does. And the dramatic, prolonged, increasingly conspicuous silence of Judge Mary Kay Viskachil in the Wolff versus Melania Trump case raises questions that deserve serious, honest analysis. I'm going to give you that analysis today. I am also going to give you my own honest thoughts on what I think this silence means. Because this channel has always been about telling you what we actually think, not just what is safe to say. Let us start with the basic facts, because they need to be clearly established before we can analyze what they mean. Michael Wolff filed his anti-SLAPP lawsuit against Melania Trump in New York State Supreme Court in October 2025. The case was subsequently removed to the United States District Court for the Southern District of New York, federal court, where it was assigned to Judge Mary Kay Viskachil. Two critical motions are now fully briefed and sitting before her. The first is Melania Trump's motion to dismiss, her legal team's argument that the case should be thrown out entirely before it reaches the stage where evidence is examined and witnesses are compelled to testify. The second is Wolff's motion to remand, his legal team's argument that the case should be sent back to New York State Court, where the anti-SLAPP protections are at their absolute strongest and where Melania's team least wants to fight this battle. The last known court filing in this case was submitted on February 27, 2026. It is now May 2026. The judge has not ruled. She has issued no scheduling order. She has given no public indication of when a decision is coming. That is over 2 months of complete judicial silence on two motions that are, by any measure, not legally complicated. They do not involve novel questions of constitutional law. They do not require the resolution of competing circuit court precedents. They are, in the landscape of federal litigation, relatively straightforward procedural questions. And they have been sitting unanswered for over 2 months. Now I want to be honest with you here, because this channel has always been straight with its audience. Is a 2-month wait for a ruling on a motion to dismiss unusual in a federal court? Technically, no. Federal judges in the Southern District of New York carry some of the heaviest caseloads in the entire country. They oversee complex financial fraud cases, securities litigation, international commercial disputes, and significant criminal matters simultaneously. A motion pending for 2 months without a ruling is, in the ordinary course of federal litigation, not extraordinary. Judges are busy, clerks are stretched, the wheels of federal justice grind slowly. I am not going to tell you that 2 months of silence is definitively suspicious, because that would not be honest, and this channel does not do dishonest. But here is what I will tell you honestly. This is not an ordinary case. This is a lawsuit involving the sitting First Lady of the United States and a prominent political journalist, filed under New York's anti-SLAPP law, raising questions about press freedom, about the Epstein network, and about the conduct of one of the most powerful households in the world. Cases of this profile, in my observation and in the observation of legal analysts who cover federal courts regularly, tend to move faster than ordinary commercial litigation. They attract judicial attention. They are the kind of cases that clerks flag as priority matters precisely because the public interest in them is so high, and the reputational stakes for the court and how it handles them are significant. The silence in this case, given its profile, given the public attention it has received, and given that Wolff himself said weeks ago that the ruling should come any day now, that silence is, at minimum, notable. And I think it deserves to be discussed openly and honestly, rather than explained away. Now let us talk about what that silence means for each side, because the impact of delay in this case is not symmetrical. It does not affect Wolff and Melania equally. The delay benefits one side significantly more than the other. And understanding which side benefits from the silence tells you a great deal about why Melania Trump's legal team has deployed every available procedural mechanism to slow this case down from the moment it was filed. The delay benefits Melania. That is the plain truth. Every month that passes without a ruling on the motion to dismiss is a month that the case does not reach discovery. And discovery is the thing that Melania's legal team is most afraid of. If the motion to dismiss fails, if Judge Viscasil rules that the case has legal merit and should proceed, the next phase of this litigation is discovery. And discovery means subpoenas. It means compelled document production. It means Wolff's legal team can formally demand that Melania Trump hand over documents that she has spent considerable effort keeping out of the public record, including, as Wolff has explicitly confirmed on his podcast, her prenuptial agreement with Donald Trump. That document, one of the most private and closely guarded legal agreements in the Trump marriage, could contain financial arrangements, clauses about the nature of their relationship, and details about the structure of the Trump household that neither Donald nor Melania wants anywhere near a courtroom or a public record. Every day the case stays in this pre-discovery holding pattern is a day that document stays in a drawer. Every month of silence from the judge is a month of safety for Melania's team. The delay is not just convenient for them, it is essential to their strategy. And that strategy of delay has been visible and deliberate from the very beginning of this case. Let us trace it carefully, because each move in this sequence reveals the same underlying intention. When Wolff filed his lawsuit in New York State Supreme Court, Melania's team immediately challenged the service of process, arguing that papers handed to a doorman at Trump Tower did not constitute valid legal notification of the lawsuit. Think about that for a moment. The First Lady of the United States, surrounded by Secret Service protection, inaccessible by ordinary means, argued in federal court that a journalist could not legally notify her of a lawsuit because he could not physically reach her through her own security apparatus. That argument consumed time and resources and forced Wolff's team to address a technical procedural challenge before even reaching the substance of the case. It was not a good faith legal argument. It was a speed bump, deliberately placed. Then came the removal to federal court. Melania's team successfully argued the case should move from New York State Supreme Court to the United States District Court for the Southern District of New York. This move added procedural complexity, changed the applicable legal standards in ways marginally favorable to Melania, and consumed more time. More weeks, more months of the case sitting in procedural limbo, rather than moving toward the merits. Another speed bump, and then came the most revealing move of all, the attempt to transfer the case to Florida. The Florida strategy deserves extended analysis because it exposes the true nature of Melania's legal position more clearly than anything else her team has done. The argument her lawyers made is that Melania is a Florida resident. The Trumps announced in 2019 they were moving to Florida. They vote there, her lawyers are based there, and therefore Florida is the appropriate jurisdiction for this case. That argument is legally arguable on its face. Residency can be a legitimate factor in venue determinations, but the legal argument is not the point. The point is what waits for Melania in Florida that does not wait for her in New York. In Florida, the anti-SLAPP protections are significantly weaker than New York's strengthened 2020 law. In Florida, the calculation of whether a legal threat constitutes impermissible speech suppression is governed by a less protective standard. In Florida, Wolff's strongest legal weapons are considerably blunted, and in Florida, there is a specific judge who carries specific significance for the Trump family. Judge Aileen Cannon sits on the federal bench in the Southern District of Florida. She is a Donald Trump appointee. She presided over the classified documents case against Donald Trump, and her rulings in that case generated significant controversy and were cited as contributing factors in its eventual dismissal. And according to reporting that Wolff himself has publicly referenced, sources inside the White House have been heard describing Judge Cannon as a future Supreme Court justice. When you hear that the White House considers a sitting federal judge a future Supreme Court candidate, and when you observe that the First Lady's legal team is desperately trying to transfer an active federal lawsuit to that judge's jurisdiction, the conclusion you are invited to draw is not subtle. Melania's team wants Judge Cannon. They want the weaker anti-SLAPP standard. They want Florida. And they have not been able to get there because Wolff's legal team filed a motion to remand the case back to New York State Court, and that motion is sitting in front of Judge Viscasil alongside the motion to dismiss, both of them unanswered, both of them silent, for over 2 months. Here is my honest personal thought on the Florida strategy. I think it was a mistake. Not legally, the argument is technically arguable, but strategically, it was a mistake because it was transparent. Every journalist covering this case, every legal analyst, every person in Wolff's legal team, and apparently every person watching this channel understood immediately what was happening. When you try to move a case to a jurisdiction where a sympathetic judge sits, you are broadcasting your awareness of your own legal vulnerability. You are telling the court, we are afraid of what New York can do to us. That is not a position of strength. That is a position of fear. And fear, in litigation as in everything else, tends to produce more of the outcomes you were trying to avoid. Now let us talk about Judge Weiskasil herself, because understanding who she is matters for understanding what her silence might mean. Mary Kay Weiskasil is a 2019 Donald Trump appointee. She practiced commercial litigation for 33 years at Simpson Thacher and Bartlett, one of New York's most respected law firms. She was confirmed by the Senate 91-3, an overwhelming bipartisan vote that tells you she is regarded across party lines as a serious, credible, and competent jurist rather than a partisan appointment. She has a reputation in the Southern District for running a tight courtroom, moving efficiently, and not tolerating delay or procedural gamesmanship. Early in this case, when Melania's team filed a letter motion requesting a pre-motion conference, a common procedural step that can add weeks to a case timeline, Weiskasil denied it within 1 day. She told them a conference was not required. File your motion. That swift response suggested a judge who understood exactly what was being attempted and was not interested in facilitating it, which is precisely why her subsequent silence is so striking. A judge who moved fast enough to deny a conference request within 24 hours has now sat on 2 fully briefed motions for over 2 months. What explains that? I have thought about this carefully, and I want to share my honest analysis with you. There are several possibilities, none of which are mutually exclusive. The first is simple judicial workload. She has other cases demanding her attention, and this case, despite its profile, has been placed in a queue. The second is that the legal questions presented, while not novel, are more genuinely complex than they appear on the surface. That the interplay between the anti-SLAPP statute, the federal court's jurisdiction, and the venue question creates analytical challenges that require more time than a straightforward motion to dismiss. The third possibility, and this is the one that I think deserves to be said openly even though it is uncomfortable, is that presiding over a case involving the sitting First Lady and her husband's administration creates institutional pressures for any federal judge that do not exist in ordinary commercial litigation. I am not saying Judge Weiskasil is compromised. I am not saying she is acting improperly. I am saying that being the federal judge who rules against the First Lady of the United States in a case involving Jeffrey Epstein with the eyes of the country watching is not a position any judge steps into casually, and the weight of that position may be one of the factors that is extending the timeline of this decision. That is my honest assessment, and I stand behind it. Now let us talk about what Wolff is doing while the judge is silent. Because Michael Wolff has not been sitting quietly waiting for a ruling. He has continued to report. He has continued to gather evidence. He has said on his podcast that new findings are continuing to come in. He has referenced recorded interviews he conducted with Jeffrey Epstein before Epstein's death in 2019. Interviews that he says contain specific statements about Melania Trump that directly contradict what she said at her press conference. He has been explicit about what he wants from discovery if the motion to dismiss fails. He wants documents. He wants the prenuptial agreement. He wants communications, he wants financial records, and he wants depositions, under oath, in front of a court reporter. Let us talk about those depositions for a moment because I want you to understand exactly what they would mean. A deposition is not a press conference. You do not get to prepare a statement, deliver it, and walk away without taking questions. A deposition is a formal legal proceeding in which a witness is placed under oath and questioned by opposing counsel, with every word recorded by a court reporter and every answer becoming part of the legal record. You cannot refuse to answer without invoking a specific legal privilege. You cannot have your lawyer reframe the question. You cannot control what is asked or how long the questioning lasts, and if you lie, you have committed perjury, a federal crime. Wolff has said he wants to depose Melania Trump. He wants to depose Donald Trump. He wants to depose Paolo Zampoli, the modeling agent who Melania claims introduced her to Donald Trump and who Amanda Ungaro, Zampoli's partner of 20 years, has called the creator of a false narrative. He wants to depose modeling agents, former associates, and people connected to the Epstein social world in New York in the 1990s and early 2000s. He wants all of them in a room, under oath, answering specific questions about specific events at specific times, and he wants their answers measured against the recorded interviews he conducted with Epstein, against the documentary evidence his team has assembled, and against the public statement Melania made at her White House press conference. The prospect of that deposition, of Melania Trump sitting across a table from Wolff's lawyers, under oath, being asked about her life in New York in the 1990s, about her relationship with Epstein, about the prenuptial agreement, about Paolo Zampoli, about the email to Ghislaine Maxwell, is the thing that drives every delay tactic, every venue transfer argument, every motion to dismiss. It is the outcome that her legal team is spending every available resource trying to prevent. And it is the outcome that moves one step closer every day the delay strategy fails to kill the case. Here is where I land on the central question this video is asking. Why has the judge been silent for months? I think the honest answer is probably a combination of all the factors I described. workload, legal complexity, and the institutional weight of the case. But I also think the silence, whatever its cause, is running out. Wolff said weeks ago the ruling should come any day now. The public pressure on this case is significant. Katie Fong's DOJ lawsuit is developing in parallel and adding urgency to the broader Epstein document story. Amanda Ungaro is giving interviews and preparing for Italian national television. The political environment around the Epstein story is intensifying rather than cooling. A federal judge cannot sit on two fully briefed motions in a high-profile case indefinitely without the silence itself becoming a story, which, as of today, it clearly has. When the ruling comes, and it will be the most important single moment in this case so far. If Viskachil denies the motion to dismiss and denies the transfer to Florida, Melania Trump's legal situation changes overnight. Discovery opens. The prenuptial agreement becomes compellable. The depositions become schedulable. The full weight of Wolff's legal arsenal, the subpoenas, the document demands, the sworn testimony, becomes deployable. If she grants the motion to dismiss, Wolff appeals, and the case continues in a different form. But the motion to dismiss, in the view of Wolff's legal team, and in the view of most independent legal analysts who have examined it, does not have strong grounds. New York's anti-SLAPP law was built precisely for situations like this one, and Judge Viskachil, whatever pressures she may feel, is a lawyer of 33 years who was confirmed 91-3 precisely because she is regarded as someone who follows the law. The silence will break. And when it does, we will be here, breaking down every word of that ruling, explaining what it means in plain language, and telling you exactly what comes next. If you want to be the first to know when that happens, subscribe and hit the notification bell right now. Share this video with someone who has been following this case and has been wondering the same thing we have all been wondering. Why has the judge said nothing? Now you know the full picture. Now you understand what the silence means and what breaks it, and now you understand why, when it breaks, everything changes. See you in the next one.